Good morning, everyone, and welcome to Mediation, the New Possibilities Hour. Today is October 29th, 2020, and we have wonderful guests today, Ellen Parker and Janice Sperow. Before we get to them, I want to remind everyone that this is part of the Will Work for Food project, founded by Natalie Armstrong Motan in the spring of this year. We don't charge for these great webinars. Rather, we ask you to contribute to a food bank of your choice if you like what you see. And we're so happy to report that the ADR and legal industries have responded magnificently with their generosity to people in this time of need. Natalie, it's always one of my favorite parts of the webinar to call on you to introduce you, to acknowledge you for your tremendous efforts in founding the Will Work for Food project, and to report on how we're doing on our fundraising so far. So please.
Well, Jeff, I don't need the applause. That's not why we do this. We do this because there are so many people with food insecurity, but thank you. I appreciate the compliment in the introduction. This too is one of my favorite parts about our program, and as of this morning, we are at $57,600 donated worldwide to food banks due to the generosity of the legal and ADR industry. So thank you, everyone.
Wow, that's fantastic. And I know that after today's great presentation, those numbers will go even higher. Our topic today is the best dispute resolution is prevention. And who can argue with that? And yet, we all need to understand it better. We have two wonderful guests today to explain it to us in more detail. Our first guest, Ellen Parker. Ellen is a retired principal and associate general counsel of KPMG LLP, where she handled the defense of significant litigation and regulatory investigations. She also served as general counsel of a television production and post-production company in New York City called MTI The Image Group, and was a litigator with two boutique firms before that. After 35 years of litigation, she's started her second season as Senior Vice President of the CPR Institute, the think tank side of the International Institute for Conflict Prevention and Resolution, where she oversees membership, engagement, and acquisition, as well as all programming and initiatives such as dispute prevention. And our second speaker today, second guest today, is Janice Sperow, who has been a longtime supporter of the Will Work for Food project. And Janice, we appreciate your support over these many months, and we're so happy to have you as a speaker this week. Janice is a full-time arbitrator, mediator, hearing officer, and judge pro tem. She has served as an arbitrator on over 350 cases and is an arbitrator for the AAA, CPR, NAM, FINRA, and many more. Janice is a former litigator with Morrison & Foerster and had her own firm, Ruiz & Sperow, a woman-owned, minority-owned firm. She's former president of the National Association of Women Lawyers. So we have two very distinguished speakers today, and I'd like to invite them to address us. Janice and Ellen, the floor is yours. Please first tell us about the food banks that are special to you, and then we look forward to your terrific presentation.
Terrific. Janice, do you want to describe? We're together doing Katerina's Club. So
yes, ever since we heard the MC's presentation, that really moved my heart. We adopted her charity, which is Katerina's Club, which specifically helps children in food insecurities in the greater LA area. So children speak to us.
Yes.
Ellen, if you want to go ahead, we'll
sure.
go first.
Okay. Thank you, everybody. I'm really excited to be here, and it's nice to see some familiar faces as well as new ones. So welcome. We're talking about prevention is the best solution. So Janice, can you explain baseline, what is conflict prevention? Why is it important? And how does it differ from conflict resolution?
Sure. The main difference here is where they intervene in the cycle. So the typical scenario is there's a dispute and it gets to a formal legal action, and then resolution comes in to try to fix it, whether it's a mediator, an arbitrator, a judge, a jury, whatever, right? And so the key there is to recognize that disputes don't start out with full-blown litigation, but rather develop over a life cycle. They might have a minor concern or a minor issue that starts to build mistrust. And then there's a communication gap, and that leads to a problem which creates a difference of opinion. And now people start to harden their opinions. And at that point, it escalates into a full-blown dispute, and everybody gets their lawyers involved, and here we are. So the idea is prevention gets to the root of the problem earlier in the life cycle of that dispute. It can be from the very beginning, before you enter into a relationship, by writing things into the contract. It can be at any step along the way. And it can even be at the end, when you learn lessons from problem number one. You learn how to prevent, hopefully, both problem number one from repeating, and maybe even prevent problem two in the future. So it's really getting in there early on. The key here is to intervene and break the costs as well. Litigation is outrageously expensive. Arbitration is cheaper, but it's not free. It's very costly. Mediation can certainly add up, although it's probably the cheapest of all of those three options. And so you really want to break the direct costs, the indirect costs, and the intangible costs. And what prevention really does is focus on really those intangible costs, which is all the damaged relationships, lost associated profits, time off mission, failed business objectives, lost opportunity, and instead maintaining that relationship. Ellen, I know that you've been very involved from the get-go on this. Tell us, how can the parties intervene early to prevent disputes and escalation?
I would say, yeah, as you have just mentioned, it's a spectrum of ways. And actually, many companies do this already and may not recognize it as a, quote, conflict prevention program, but they're doing many things. They can start with sort of the end of a prior dispute, a root cause analysis. What caused that dispute? Really break it down and figure out how they can prevent something like that occurring in the future. They can have risk management folks looking at service, evaluate and anticipate where can conflicts or problems, future litigation arise, and work from there. When business partners are identified, it's really important, and they can build an element of trust and confidence into the relationship, and even before they start contracting. But putting in contract mechanisms, as you've mentioned, in place as well. As they're negotiating, they can bring in a third-party neutral as a deal facilitator. That often helps. And as I said, building into the contract mechanisms for decision-making, practical escalation processes to solve strategic and operational disputes along the way. And that can be done either or both by identifying, training, and empowering business people to manage the business relationship. And that can be done alone or in conjunction with a third party along the way. And we'll talk about how those have been done in certain industries, and some of the work CPR is doing along that line as well. But the key is in a business relationship, committing to open dialogue and communication, and committing to the business relationship with some of these mechanisms in place. Early identification of friction, and trying to resolve it, nip it in the bud before, as we say, it becomes a do or die, I win, you lose, bifurcated position. So that's sort of ways I think they can do it. Janice, as a neutral, and I've mentioned a couple of these, how can you help parties prevent conflict?
Well, that is actually a thing that I wanted to share with everybody who is a neutral here, and that is there's still a role, very important role for neutrals throughout the process. You can have a standing neutral, as Ellen already mentioned. You can have a mediator who is available on call. There's all types of ways throughout the entire process. You can even have a arbitrator or mediator at the very beginning during the contract negotiations to show how that might play out if it ever got to litigation. One of the things I wanted to share was how I got involved in this, because it was, really just a quirky thing. I had a arbitration. It was an issue arbitration. This is a long time ago, and I won't say specifically how long ago. However, it was issue arbitration, and so both sides, they had a continuing contractual relationship. They wanted it to be profitable, but they were hitting some snags, and so they brought it to arbitration. And this is long enough ago that mediation would have been better, but they didn't really know about all that. And so after it was over, they were both so happy. They jointly came up to me and said, this was really helpful. This really ironed out our issues. Can we just call you? I mean, can we just jointly, call you? And I said, sure. Yeah, we can do that. And that's how I got started with prevention. They started calling me before anything got to a real problem by saying, you know what, we have a different opinion about this. What do you think? Blah, 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 blah. And it was funny because it was immediate. They picked up the phone. It was smaller issues, so it had a lot of de-escalation efforts, and it saved tons of cost. It also helped balance a little bit an inequitable bargaining position. I'm not saying I helped the smaller side out at all, but it helped them have a voice about what might have been fair, or how a third party might see it in terms of fairness in the law. It's also a different role the neutral plays than counsel. When you're the counsel doing the contract deal, your job is to get the best deal possible for your client. That's how you view it. Whereas a neutral has a bigger picture of the whole deal. They see the relationship. They see the future 5 years down the road. And the funny thing is, my husband likes to tease me and say, you have a habit of talking yourself out of work. Because what ended up happening was I had such a deterrent effect that after a while, they laughed and sent me flowers and said, we don't even have to call you anymore. Now we just say to each other, what would Janice say? How would Janice handle that? Shall we call Janice? And then the next thing you know, problem solved. And so to me, that's a huge success. And yes, did they then have a lot of problems to send me? No, but did they then turn around and refer all their friends? How do you think I got 350 arbitrations? Yeah, they did. And so even though those executives are long since retired, we all three of us have a fondness spot for each other. And I remember this really as the bud of how I got involved in on the crusade, if you will, of dispute prevention and the economies of scale it brings. I'm not the only one who's been on the forefront, Ellen. You and CPR especially really pioneer in this area, as has Jim Groden and the construction field. Can you share with us what lessons that you've learned and what CPR's initiatives are in this arena?
Sure. Well, the lessons learned are, it is a paradigm shift for most organizations and most people involved in dispute resolution. Sometimes met with skepticism, but we've seen some real results from it as well. What CPR is doing, and I'll go back to sort of Jim Groden, who, as you said, has been the pioneer and mostly in the construction industry. But about 10 years ago, Jim Groden, along with Andrea Schneider and Chris Honeyman, formed for CPR a exploratory prevention group and started the Dispute Prevention Initiative. And they did a fair amount of research on this, and prepared a number of background papers, research studies, exploratory materials. They've written a fair amount, and their materials are on, or many of their materials are on the CPR website under the resources section, available to everybody. And I would say one of the best papers that came out of this is a chapter in the Negotiator Handbook, but it's also on available publicly on SSRN, and I think probably also Jim's website, called Thinking Ahead. And it's a great paper for anybody interested in this topic. But as a result of this exploratory committee and dispute prevention initiative, all these papers, other publications, CPR formed in 2016 a dispute prevention committee, which is comprised of our membership of corporate counsel, outside counsel, and neutrals who come together to work on prevention initiatives beyond the construction industry. And you know, as we said, Jim came from construction, and the use of dispute review boards and the use of standing neutrals throughout a construction contract. The Dispute Prevention Committee has put on some programs, and most recently we're polishing off a suite of model clauses for companies to use for long-term relationship contracts. So joint ventures, mergers and acquisitions, affiliation contracts, any sort of really long-term vendor back office relationship, these would apply to. And this suite of model clauses will have a provision for no neutral and a provision for standing neutrals and standby neutrals. And it's a step-up clause similar to what most of us are used to, but it has a much more detailed process for the discussion and escalation of disputes, of conflicts. I'll call it a conflict or friction point during the relationship, because the goal is commitment to working it out. But if it can't get worked out, it does eventually step up to arbitration or litigation if that's what the parties preferred. So we're going to be launching those very soon. CPR has also launched a panel of dispute prevention panel from our panel of distinguished neutrals. And these are arbitrators and mediators with experience in the earlier facilitation of resolving conflict among business partners. And we've got programming on prevention as well. And I see Deborah Hilton here. Deborah helped us, was one of our panelists on the June 4th dispute prevention panel that we put on, called Prevention, the Imperative is Now. We also did a town hall. We co-sponsored a town hall for the ABA Dispute Resolution Section Task Force on Conflict Prevention. And that was a half-day exploratory panel, series of panels and discussions on prevention as well. And then we've got some future programming as well. And November 12th, if anybody's interested, next month, one of our open programs will be on prevention and dispute resolution in the healthcare and life sciences field, but the first panel will be specifically on prevention. And finally, just for this answer, because I've gone on for a while, our annual meeting, our upcoming annual meeting next January, is all about prevention. And it's going to be prevention, similar title here, resolution without dispute. And over the 2 days, we'll be talking about the skills and techniques for this early prevention initiatives. So that's what CPR's been up to. So Janice, I think, you know, as we've talked about this, most people understand prevention in terms of de-escalation, stopping the small disputes from turning into big ones and eventually legal action. But how do we address prevention in terms of avoidance? In other words, avoiding conflicts in the first place?
Well, that's a very good question. And by the way, they're being very modest. CPR's programming has been exceptional
Great.
on this area. I really do see them as the forefront of this next phase. And let me just say, as a neutral, that where we are with prevention, and I think the mediators in the Zoom room can understand this, is where we were 30 years ago with mediation. Nobody knew about it. What is it? It sounds new. It sounds like some touchy-feely thing. What happened? And here we are, and it's an established practice. Courts are mandating it in several places like New York. And this is the future. This is where we're going as a industry. All right, so let me actually answer your question.
Thank
how
you.
do we stop disputes before they even happen? How do we do avoidance? Well, one of the things that I've worked on is the concept of foreseeability. Anybody who's done a contract dispute knows that as an arbitrator or mediator, you're going to look at whether the damages that are being asked by the claimant were foreseeable at the time the parties entered into the contract. Well, I took that concept, which is very basic to contract law, and it actually plays a role in torts as well through proximate cause, as we all know, and turned it on its head. Well, if it was foreseeable at the time of the contract, why didn't we foresee it? Meaning, let's decide what's foreseeable and write into the contract how to avoid it, what we're going to do if this happens, right? Now, some things are completely unforeseeable. Did we know COVID was going to turn 2020 on its head? Not really. But many things are foreseeable, like a supply chain problem, like new legislation that was pending at the time the parties wrote their contract, like some risk assessments about a competitor poised to enter the field. These are things you can see coming and prepare for in your contract of here's how we're going to handle that. And more importantly, here's how we're going to allocate that risk among the different parties and what the response team is going to look like. And we might even have, not written into the contract, but an action plan as part of our joint business venture of here's 5 scenarios we might consider if that actually happened. And so that's how one of the ways. Another way is, I love money. Everybody loves money. So bonus pool, right? You get a bonus if everybody achieves the contract objectives. You don't get a bonus if no one does. When you do that, everybody all of a sudden becomes extremely collaborative. I mean, because one, they genuinely like each other, but now they have a common goal. They have common objectives, common business interests that are actually more direct than the business deal itself. They already have a common goal, which is we both want this to be a win-win, profitable venture. Of course they have that. That's true in any deal. But now they have direct lining your pocket incentive, and that's important. Another key thing that I've learned is executive prioritization. If you get the senior management, I'm talking the big guns, right? CEO, CFO, CIO, all those folks right up there saying prioritization of this dispute prevention is key to my agenda. Bonuses will be tied to that internally. Training will be offered internally for that. And by the way, parentheses, that's another role for neutrals. Who do they need to train them? The people who know how to do it, right? Okay. It's another aspect that you can help in. And when they prioritize it, and you have both sides to the contract doing that, and that filters down, then you're going to avoid problems because they know that is what their bosses are basically looking for. You want to advance in this company, you better get on board. The other thing is even outside counsel. Outside counsel, you might think, well, my bread and butter is litigating when a problem happens. But how about a structure of payment and use of outside counsel where one of the roles is to come in as an expert, not as a representative of a party, but a representative of the deal? What would the contract look like if you had basically a third party neutral lawyer examine it from all sides?
Mhm.
I've actually done that. They had a fight, they brought me in, same two executives I was talking about, but it was for a spin-off joint venture in Guam of all places. And in the Japanese royal family was involved, and there was cultural issues, and there was all kinds of things going on. And they just said, Janice, what should go in this contract? Our lawyer's saying this, their lawyer's saying that. What do you think? So it takes it to another level of third-party neutral use. I mentioned the senior executives prioritizing prevention, and you were in-house counsel, Ellen, for years before you joined CPR.
Yeah.
How did you see prevention in that role, and have any other companies implemented prevention policies in a successful manner?
Yeah, it's in-house counsel, and I completely agree with everything you said about the culture and the coming from the top leadership, because the CEO top leadership really does set the tone, and having a hand in that can also help control zealous outside counsel who may be thinking, I just have to get the best deal for my client, not recognizing that the best deal is a fair allocation of risk rather than none of the risk and putting it all on the other side. So I think what I saw was when senior leadership set that tone, that was absolutely the most helpful thing. And also, as I'd mentioned earlier, the root cause analysis, wanting to know when something did go wrong. I found in my old firm the senior leadership, the various business units would ask me or my colleagues to come to analyze, how did it happen? How can we prevent it again? Come explain it to us. Do you have ideas for control changes, process changes? And they, being receptive to that helps a lot, rather than getting defensive and saying, well, this is how we're doing it. So, culture shift is important if they're not already doing that in terms of risk management and anticipation. One of the really interesting things I've learned along the way through CPR is learning about two major companies who are doing this each in somewhat different ways, but both with significant success. Some folks who have attended CPR programs on dispute prevention have probably heard Howard Karsman of Intel come and talk about the program that he implemented in 2016. For those of you who don't know Howard, he is the global construction claims manager for Intel. And developed a comprehensive and early dispute resolution. It has been deployed on major projects, both domestically and globally. And his approach was to set up two layers. One is an executive committee between the owner, which would be Intel, and the subcontractor. And it's similar to what we would think of as the negotiation phase of an escalation clause. But it's very specific rules and processes were put in place for this executive committee of the parties, business people, to get together on a monthly basis, look at the progress of the project, discuss and resolve any issues that have come up. And they would continue this way monthly throughout the project. If an issue had not been resolved by 60 days, there would be, and there had been identified in the contract, a standing neutral to whom the parties would go, who could then advise or resolve. with the issue that the parties had. The choice is theirs. The standing neutral also had a role if the parties agreed to periodically check in with the parties, both individually and jointly, and see, this, whatever they could do to keep the relationship and the project on track through the end. And from 2016 until today, Howard informed me last month, they had $10 billion in construction projects under this program. And wow, and up until this summer, perfect record, no arbitrations or litigations arising out of these projects. As of the end of the summer, he unfortunately said, small in comparison to the amount at issue, or when the amount of the projects has to the $10 billion small, but an $11 claim that the sub wanted to bring to arbitration. So he was a little chagrined that he no longer had his perfect record, but I think it's pretty close to perfect that way. Another company that has implemented something really innovative was Monsanto, which is now part of Bayer Corp. And Scott Partridge, at the time that Monsanto put this into effect, was on the business side. He had been the general counsel. He was on the business side and designed and launched Monsanto's program called Relationship-Based Dispute Resolution and Conflict Avoidance Model. And through this forward-looking focus, Scott created policies, established programs, and negotiated long-term agreements with competitors, which not only led to the resolution at the time he put this in, which was, I think, around 2014 or 15, resolution of all then existing disputes, successfully prevented any new contract-based litigation going forward. And Scott did not use third-party neutrals for this program. He was able to get executive buy-in to train and empower business executives, business unit owners, had the business relationships, they were responsible. So I think it used some of the points that Janice mentioned in terms of incentives and being able to focus on collaboration and future relationships to keep the relationships on track. But as of the end of June, when Scott spoke at the town hall that we held, he had said Monsanto has had no litigation with any competitors or major customers since the implementation of that program as well. So it's interesting. I think
it's impressive.
It's really impressive, and I'll say that interestingly, when we try to socialize this concept among some outside counsel or in-house counsel, their skepticism that it can work until we mention these examples, and suddenly folks get really interested in how did they do that. So anyway, Janice, you serve on CPR's prevention panel. What are some of the new areas you are exploring as a dispute prevention specialist?
Well, that's an interesting question, because one of the things, when I was at MoFo, I did a lot of intellectual property, trade secret litigation, and as a result, I wear different hats. I'm kind of a secret nerd, and and my husband's a scientist, and so I love all that. And so I have the honor of not only being on the CPR's dispute prevention panel, but also on American Arbitration Association's emerging technology panel, which deals with new kind of cutting edge trends. And one of the things that I have focused on, because I like to put all my hats in one bucket, is thinking about how those two very different concepts merge. In other words, how to use some of these emerging technologies in the prevention field. So let me give you an example of what I'm talking about, because it sounds esoteric until you actually break it down. So one of the things is predictive analytics. So what does that mean? It sounds very fancy. It's basically a technology that learns from experience, which wonks will call data, right? But that's experience. And it uses that data, that experience, to predict the future behavior of individuals to drive better decisions. Okay. Now, this is already used in many, 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 many industries. Okay. You've got insurance uses it all the time, pharmaceuticals. Probably the area it's best known that you guys would relate to the most is financial institutions. Because what they do is they use customers' credit history, loan application, customer data, and their other financials to predict their likelihood of paying a credit on time. That's what credit card people do. And that is predictive. However, what I found is that predictive models could use these patterns found in historical experience and transactional data to identify risks and opportunities presented in any particular proposed venture or contract, which the parties could then address either in their contract directly or at least in the relationship to exploit the opportunities and minimize those risks. Here would be an example. Let's say you're doing a deal and it involves two companies, I won't name names, who have lots of private data. Lots of private data, okay? Not that this is in the news or anything. And they then could use take an algorithm of what data leaks have transpired in the past to predict the likelihood of any leakage under their joint venture of this very private data. Okay? And then take steps to prevent that. At a minimum, I mean, sure, there might be other leaks they didn't foresee, but at a minimum, they're mitigating risk, they're mitigating damage, and look at how responsible they look to a judge, jury, or arbitrator who's going to say, well, what more did you want them to do? They did this and this and this and this. I mean, all of a sudden, they're not only reasonable, but setting a standard. Okay, another example. You could look at the legal landscape of current and pending legislation and design what's called deep learning algorithm. That's just another type of predictive analytics to predict the likely magnitude of an attorney fee award in the event of a class action against the businesses on that project. Okay, you can do that. You now can actually do that as long as you've input the data. The prediction is only as good as the data you input, and it does require lots of inputting data, but it's done. So let's look at another example. I'm sure everybody has heard now about blockchain, right? Everybody blockchain. But does anybody actually know what that means? So I'll tell you what it means. Blockchain comes from two words. Block means growing lists of data records, which us wonky folks call blocks. It's a block of data. And then it chains those different blocks together, blockchain, using cryptography, right? And so then it uses the cryptography functions to essentially create an open ledger. So now I really am aging myself because I remember days when there was ledgers and you would write in the ledger the business, here's what happened here, right? And so it creates an on-screen open ledger of transactions available for everyone to see who is a party to that blockchain data group, okay? And the key part, because the link in the chain is the cryptography, it's very, very difficult to hack. Now, I'll tell you who's been using this for quite a while. Cannabis industry. Because they've had to deal with cash. For a while, banks didn't want to touch it. So how did they make sure people weren't, stealing money right and left? They've been doing blockchain forever. They just don't talk about it. That's what they do. Okay. Then you've heard of smart contracts, right? Smart contracts is not really a contract. It's a computer program more than a traditional contract. And it basically enforces the parties' agreement automatically based on the contract terms that were inputted into the code. All right. So now, because I like to put everything together, you can take the blockchain together with the smart contract and the predictive analytics. Because, remember, blockchain has to have all this data to function, right? So if you take blockchain and the contract and you use predictive analytics, you can basically identify potential problems or behavioral patterns that would make the smart contracts even smarter. You would avoid conflict. Okay. Let me talk about one more and then I'll stop because I could go blah 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 forever on this. All right. Augmented reality. Has anybody heard augmented reality? A lot of you probably heard virtual reality. So let me talk about augmented reality. Augmented reality basically can help inform strategic decision making. It transforms, again, large volume of data and analytics into images, which are then superimposed on the real world. So virtual reality it does the same thing, but it imposes it on a virtual world. Whereas augmented reality imposes the data on the real world. So let me give you a classic example that if you have any kind of kids at all, you will have heard of. Pokemon Go. Do you remember that craze where everybody's looking for the Pokemons on their smartphone? That is augmented reality. They took little Pokemons and they put them in the real world for you to find, okay? But it doesn't have to be a game. I mean, gamers have been using that for a long time, but why would we do just a game? What about this? Taking two-dimensional digital data, overlaying it on the three-dimensional physical world to show people the problems as they exist. For example, you have an on-site person. I see a problem, like visually I see a problem. Put on your augmented reality glasses, and now the executives in the boardroom see the problem too. Or a standing neutral sees the problem, or an off-site expert sees the problem, and they can advise you immediately, real time, some options about how to fix that problem. Now, I know you probably think I'm talking science fiction, but that's not true. They're already doing this in several big companies for training, especially with heavy machinery. The workers are being trained where they're actually seeing stuff over the machinery to capture the real training instead of telling you how it would work. And that has been so much more effective. I'm surprised OSHA hasn't jumped on it because the safety record, once you do that, skyrockets. And why does it work that way? The reason why it works that way is it's how our brains work. We receive data and information from all five senses, but 80 to 90%, think about that, 80 to 90% comes from the vision. So if you can actually see the problem, then you can address it and you can do something positive with it.